Today on Diagnosing Health Care, we're discussing the proposed leadership of the Department of Health and Human Services under the second Trump administration and the top ticket items for these potential new leaders, and how our listeners, as healthcare and life sciences businesses, can advocate for themselves and their business interests amidst all of the change. Hello and welcome. I'm your host, Marjorie Scher. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our New York office. Today, we are recording on January 23rd, 2025, and today is day 3 of the second Trump administration. As with any executive transition of power, the only thing that we can anticipate for sure is change. President Trump has selected some marquee names to lead CMS, the agency overseeing government-funded healthcare services, the FDA, which is the agency overseeing the development and safety of foods, drugs, cosmetics, and products, and the Department of Health and Human Services, the cabinet level entity over both CMS and FDA. It is critical for healthcare and life sciences businesses to understand what might and what might not change during this transitionary time and the ways for businesses to advocate for their needs and priorities amidst the potential for such change. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. I'm pleased to welcome 3 of my EBG colleagues for the discussion today. First, we have James Boiani, a member of the firm in our Washington, D.C. office. James, hey, welcome to the show.
Hi, thanks for having me.
Also joining us today is Rachel Snyder Good, Strategic Counsel, sitting in both of our Baltimore and Washington, D.C. offices. Rachel, good afternoon. Thanks so much for joining.
Looking forward to the conversation, Marjorie.
And finally, last but not least, we have my colleague, Rob Wanerman, member of the firm, also in our Washington, D.C. office. Hey, Rob, good afternoon. Great to have you.
Hi, Marjorie. Looking forward to discussing these issues.
And so, Rob, my first question is actually for you. I'm hoping that you can help us set the scene. And before we get into the weeds of what might and might not change, I'm hoping that we could first cover the Department of Health and Human Services family tree. Can you walk us through the relationship between DHHS, CMS, FDA, and who is sort of slated to run each of these organizations?
HHS is the cabinet level agency under which there are 13 operating divisions. HHS has the largest single budget in the federal budget, approximately 28% of the federal budget in 2025, or about $531 billion. Within those 13 operating divisions, the ones that most of us are familiar with include the Centers for Medicare and Medicaid Services, which operates the Medicare and Medicaid programs along with the Children's Health Program and the health insurance marketplaces established under the Affordable Care Act. Also, equally important is the Food and Drug Administration, which regulates drugs, devices, biologicals, animal products, and the food chain to ensure safety and efficacy. Listeners will also be familiar with the Centers for Disease Control and Prevention, which is the largest single public health coordination agency in the country, and the National Institutes of Health, which conducts biomedical research and grants billions of dollars in research grants to over 2,000 institutions in the United States and around the world. Now, HHS is a cabinet level position, but also within HHS, the CMS administrator, who current nominee is Dr. Mehmet Oz, must be confirmed by the Senate. And the Food and Drug Administration is also subject to Senate confirmation. And the appointee for the FDA is Dr. Marty Makary, a physician at Johns Hopkins Hospital. As I said, these are political appointees, but they are also supported by a wide range of individuals with medical, health policy, and research experience.
Got it. Lots going on, lots and lots of dollars flowing through DHHS and those 13 sub-organizations. And I'm glad that you brought up Dr. Oz, Dr. Makary, and RFK Jr. These are definitely 3 names that have been in and out of the headlines over the last couple of months. But Rachel, I'm hoping that you can sort of walk us through who these individuals are, what their interview process is, and when we'll know whether or not they have the job.
Absolutely, Marjorie. So there are certain positions within each agency that have to go through the process of advice and consent, which is outlined in Article 2 of the Constitution. At HHS, these positions include, but are not limited to, these big names that we've seen in the headlines: HHS Secretary, Administrator for CMS, and the FDA Commissioner. The nominations clause allows the president, in this case, Donald Trump, to select who he wants to lead his executive agency, but gives the US Senate veto power essentially, in that they can't pick who they want, but that can, if they do deem the person the president picked to be unqualified, they can vote not to confirm. So for healthcare nominees, because there are two main committees in the Senate that have healthcare jurisdiction, different committees will have hearings for different nominees. RFK Jr., as the nominee for HHS Secretary, will have hearings in both the Senate Finance Committee and the Senate Health, Education, Labor, Pensions, or Senate Health Committee. Dr. Oz, as the nominee for CMS Administrator, will have a hearing in the Senate Finance Committee. And Dr. Marty Makary, as the nominee for FDA Commissioner, will have a hearing in the Senate Health Committee. So nominees can't go to the Senate floor for a full vote of the full Senate until they've been voted out of committee. Once they get to the full Senate, nominees need to get a simple majority or 51 votes. Currently, Republicans' majority is a 53 to 47 majority, which means that any nominee can only lose 3 Republicans and still get nominated. Should the vote be tied at 50-50, Vice President J.D. Vance would then be able to step in and break the tie as the president of the Senate. So nomination hearings have started, and Secretary of State Marco Rubio has already been swiftly confirmed by his Senate colleagues. RFK Jr.'s nomination hearing in the Senate Finance Committee will be Wednesday, January 29th at 10 a.m. There has been some controversy surrounding RFK Jr., including pushback both from doctors who are concerned about his controversial positions around vaccines, as well as from conservatives that are concerned that RFK Jr. is not pro-life enough. RFK Jr. has been meeting with both Republicans and Democrats, while many of President Trump's nominees are only meeting with Republicans. As someone who worked on Capitol Hill for over a decade before coming to EBG, I know that off-committee members pay close attention to these hearings and look to certain on-committee members to help them decide how to vote should the nominee come before the full Senate. I think someone that many off-committee senators on both sides of the aisle will be watching and learning from is Senator Bill Cassidy, a Republican from Louisiana who is both a member of the Senate Finance Committee and chair of the Senate Health Committee. Cassidy is a physician who has been a vocal advocate for approved vaccines as a part of overall health. He is one of the 1/3 of the Senate that is up for re-election this cycle, and he is one of only 7 Republicans who voted to convict Trump in 2021. Cassidy had a pre-hearing meeting with RFK Jr. and is expected to participate in and vote on RFK Jr.'s nomination in the Senate Finance Committee, led by Republican Senator Mike Crapo of Idaho. This is the committee that will ultimately decide whether RFK Jr. can proceed to the full Senate for a vote. It is expected that Cassidy will then hold his own hearing in Senate Health the next day. This will be an opportunity to shape how off-committee senators view RFK Jr. and could impact momentum before a full Senate vote. Dr. Oz and Dr. Makary are unlikely to get hearings until the top-tier cabinet positions are filled. I would note that there is not the same concern for Republican senators about these candidates on their pro-life positions that there is for RFK Jr.
Wow. So it's not a rubber stamping. It's not a shoe-in, so to speak. There is some real consideration, and it sounds like not that many votes to lose or to change. Thank you both, Rob, Rachel. Very helpful for me to understand the playing field, the players, and now to carry that analogy one step further, let's get into the game itself. I'd like to look specifically at each agency. First FDA and then CMS. So, James, starting with you to talk about the FDA, what do you see as some of the hot ticket items that you expect to be under close review during the Trump administration? Do you think all of these items are really ripe for change? Do you think some of them will just, be subject to scrutiny alone? And where do you think the real action will take place over the next 4 years?
Yeah, I mean, I think there are, several areas that they could see a lot of activity. Certainly, probably top of mind are laboratory developed tests. There was a final rule that came out back in May of 2024, where FDA, beyond asserting jurisdiction over laboratory developed tests, which are in-house tests developed by clinical laboratories, actually set up a framework for review and approval of those tests to be phased in over the next 4 years. This is a major step towards regulating these internally developed tests, which haven't been regulated by FDA, as they say, as a matter of enforcement discretion for the past 50 years. And it creates a very large expansion of regulated entities. And so I think for that reason, that's going to get a lot of scrutiny from the incoming administration, because philosophically, if you're trying to cut regulation, if you're adding thousands or tens of thousands of labs to the regulatory framework at FDA, that's going to, get some attention. I think another area that is ripe for attention is the drug compounding space. Drug compounding has certainly been a hot topic recently with the growth of GLP-1s and both the expanding indications at FDA and the expanding demand in the U.S. For weight loss, diabetes, and other conditions. I think sleep apnea is now on the list as well. And I think that compounding has been filling a role while those drugs have been in shortage. There is some litigation around removing products from the drug shortage list, which allowed compounders to make them. And there are various authorities FDA could use to modify the landscape of what compounders can and cannot make. It's essentially left almost exclusively to FDA to decide what's on the list of what you can compound, when you can compound it, et cetera. And, in the first Trump administration, with Commissioner Gottlieb, there's a lot of interest in expanding competition as a way to address drug pricing. And he was looking at it through the lens of making the generic drug approval pathway more efficient. I think you could see potentially, investigating whether compounding could be another tool to bend the cost curve to some degree for products. And so I think that's something that might be percolating. I think, a third issue I'd keep an eye on, there off-label communications. FDA just in the final days of the Biden administration finalized a guidance for scientific communications regarding unapproved or off-label uses of medical products. There are a lot of First Amendment issues around communications that companies can and can't make that have come up in court several times. And I think that philosophically, I would expect the incoming administration to want to relax controls over speech, to at least some extent, maybe to a very large extent. And so I think you see those sorts of policies getting reviewed. That'll be driven by, obviously the appointees we're talking about, but also the Office of Chief Counsel, whoever is finally appointed at FDA, and it's sort of their philosophical thinking as sort of the head lawyer at FDA. So I think it remains to be seen how much of a change, but I would certainly expect that would be, a point of review. And finally, too, just, approval standards for products. It's important to remember that Rob touched on this, right? HHS is at the top and FDA is subordinate. If you look at the actual statute, the Food and Drug Cosmetic Act, that FDA is administering, it doesn't say FDA has the authority to do this. It says the Secretary of Health and Human Services does, and then internally the agency delegates down to FDA for almost everything they do. There have been instances in the past, actually during the past Trump administration, where HHS has gone in and overruled FDA and said, no, FDA might want to do it this way, we're going to do it that way. So when we're talking about Mr. Kennedy's appointment to HHS, it's not just like he'll be overseeing it, but FDA will do it at once if he wants to. Obviously he'll be talking to the commissioner, but if he wanted to, he could say, okay, I'm going to pull this back just by administrative action. HHS is now going to look at the vaccines. Yeah, I mean, they could try and do things like that. And there are various legal and regulatory issues around that. But just in terms of the underlying structure of the statute, that's a possibility. So it could be a very dynamic time.
Yeah, I think dynamic is a great word to describe that. I think what you're describing here is tensions potentially between industry and agency, and then agency and cabinet, and it's really yet to be seen sort of how those who's going to align with who and how everyone will interact. And so, Rob, I want to turn to you with the same question with regards to CMS. What are some of the hot ticket items that you expect to be under close review under the second Trump administration? And, which ones do you think will receive scrutiny alone? Which ones will be most ripe for change itself? And where do you think that change might turn out?
Well, to start out, the level set, keep in mind that there are many of the changes that may be proposed or discussed can't be implemented with the stroke of a pen. Many changes require either legislation or public notice and comment rulemaking. And this is especially true for the Medicare program because Congress has mandated rulemaking for a very broad range of categories affecting that program. But starting with Medicare, there may well be an effort to expand the scope of Medicare Advantage, which is the portion of Medicare that is contracted to private parties. One proposal that's gotten attention in the press is to expand the scope of Medicare Advantage to make it the default option for enrollees, whereas right now the traditional Medicare program administered by CMS is the default. Other possible proposals include an implementation of site neutrality for Medicare reimbursement, which means that the program would pay a single reimbursement rate for procedures regardless of the location where they are rendered. So, example, the same procedure furnished in a hospital outpatient clinic, and ambulatory surgical center would all be paid the same rate. This would give a big boost to outpatient facilities such as ambulatory surgical centers, but would disadvantage hospitals. So a proposal like that, you would expect to see a lot of pushback from the thousands of hospitals around the country. Another possible proposal is the elimination of drug price negotiation by CMS, which was one of the achievements in healthcare that was touted by the Biden administration. Turning to Medicaid, we should expect to see a range of efforts to reduce federal spending for the program, including turning Medicaid into a block grant program with spending caps that may not necessarily be tied to the use of services, an expanded application of the waiver provision, where states can request waivers from the minimum statutory requirements for federal financial participation, the federal matching funds in Medicaid, and legislation to reverse the federal funding for Medicaid expansion that was part of the Affordable Care Act and other reductions in federal matching funds going to the states. Now, the effect of that, since Medicaid is a joint federal state program, may mean that for states, they'd be forced with the option of either raising taxes to make up the shortfall or cutting services. So keep in mind that if these proposals go through, they may result in changes that lead to reductions in services. Against that backdrop, you have to consider that although the largest group of Medicaid enrollees are under age 21, the largest group of Medicaid expenditures go to elderly in long-term care and the disabled. Those dynamics and those ongoing facts may make it very difficult for Congress to vote for those types of changes.
I think we heard a lot in here. I know, Rob, you and I work very closely in the Medicare and Medicaid space together. And I'm wondering if you could just expand a little bit on some of these ideas. Are they advents, would you say, of Mr. Kennedy, Dr. Oz, or are these really sort of repeat conservative ideals that we see brought up in several Republican administrations over the years?
Many of these have been a cornerstone of conservative policy think tanks and papers, especially turning Medicaid into a block grant program, certain expansions of Medicare Advantage, and aggressive uses of Medicaid waivers. In fact, during the first Trump administration, there was a flurry of Medicaid waivers that went through CMS at that time. These ideas are not new, but we now have the foundation, at least, for a very aggressive application of these objectives.
Yeah, really interesting. And I think that that's a nice segue into my question for Rachel, which is that we understand that these two agencies have their set domains. We understand that they typically sort of review and re-review the same sets of guiding principles year in and year out, but we also understand that they don't work in a vacuum. So Rachel, can you tell us a little bit about what are some of the macro factors that impact the ability of any of these agencies to advance the conservative policies that Rob and James were just talking about?
Yeah, so there are two congressional actions or macro factors that Republicans will be able to use because they have what's called unified government. And just taking a quick step back for some context, unified government is when the same party controls the White House, the U.S. House of Representatives, and the U.S. Senate at the same time. And unified government is not uncommon. The Democrats had unified government for the first half of Biden's term, and Republicans had unified government during the first half of Trump's term. So these two macro factors are reconciliation legislation and CRA action. And so, what is reconciliation? So, budget reconciliation is a mechanism that was created back in the Congressional Budget Act of 1974. It allows for expedited consideration of certain legislation that pertains to tax, spending, and the debt limit. In the Senate, reconciliation bills aren't subject to the filibuster, meaning that it can pass into law with a simple majority. So, the Congressional Budget Act enumerates the parameters of what can go into a reconciliation bill. And what's called the Byrd Rule provides a tool to strike extraneous provisions outside of the basic purpose of implementing budget changes. The Senate parliamentarian is the ultimate arbiter of what makes it into the reconciliation bill. And reconciliation bills are limited to one reconciliation bill per annual budget resolution. Some examples that have passed through reconciliation are the Inflation Reduction Act, which Rob mentioned, that included the provisions to allow Medicare to negotiate drug prices. I was on the Hill working in House Democratic leadership working on that legislation, so understand the ins and outs of this process. But also, the Republicans used it to pass the Tax Cut and Jobs Act, or the Trump tax cuts, that expire later this year. And what we've seen is that President Trump and the 119th Congress are already planning for a reconciliation bill that would pass this spring that would prevent the Trump tax cuts from expiring while also addressing immigration, energy, and other campaign promises. And what we've seen as we've started to see their proposals coming out is that Medicaid provisions, these conservative policies that come up over and over again, are in their proposals as ways to save money within the budget, to cut different Medicaid services or to block grant or to do other provisions to change the way that Medicaid functions. So, personally, I feel like they have set a very aggressive timeline for themselves, considering that the House and Senate need to pass identical budget resolutions to get the process started. And there's a very slim majority in the House. But I'm excited to see what happens and to follow this process. And then the other tool I mentioned is the Congressional Review Act, or CRA, that allows for Congress to initiate what's called a joint resolution of disapproval to overturn or prevent from going into effect a recent federal agency rule or interim rule. So, because these joint resolutions of disapproval require the president's signature, CRA action generally occurs with the start of a new presidential administration as a way to undo regulatory efforts from the end of the outgoing administration. Rules that were released within the defined 60 days of continuous session look back period are ripe for CRA action. In 2017, we saw President Trump use CRA with the 115th Congress 16 times to eliminate President Obama's regulations. The Biden administration learned from this and rushed to put out their more controversial regulations, like the LDT, or laboratory developed test rule that James mentioned, before the look back period, so that it would not be eligible or ripe for CRA action. The thing about CRA action is that it's a very blunt tool. It just eliminates the rule as it was. It's time restricted because of the look back period. And it's limiting in that once a regulation is undone by CRA action, the issuing federal agency is barred from adopting the same or substantially similar regulation in the future. And then while we're on this topic of getting rid of rules, eliminating rules, I just wanted to touch here on the third branch of government, the judiciary, and particularly the Supreme Court. We saw earlier this summer that the Supreme Court overturned the Chevron doctrine that was very longstanding. This doctrine deferred to agencies' reasonable regulatory interpretation of ambiguous federal statutes. The decision in Loper Bright Enterprises v. Raimondo that overturned Chevron was not a healthcare case. However, as healthcare is such a highly regulated industry, this decision will have serious implications for the healthcare industry. And I just want to say that I wrote a piece on how the end of Chevron deference changes the relationship between the healthcare industry, federal regulators, and Congress. We'll link to that in the show notes. I think it's really instructive of how things are going forward. And I think it's just important to know that there are nuances here and that we're in a new age, and maybe we'll touch on it later in the podcast, but important to know that that's out there as well.
Good foreshadowing. I 100% want to touch on this a little bit more in the podcast. Not for any lack of macro factors, but I do also just want to ask you one question about the 22 executive orders that we saw within the first day or so of the Trump administration. It's my understanding that the executive orders did not make any major healthcare changes. I was just wondering if you could touch on those as well.
Looking through, I haven't read through each and every one of them, but I
Right.
have been monitoring the things that I look closely for. And so we saw in the executive order on that there are only two genders. There was some fetal personhood language in there about life beginning at conception, which implicates not just abortion, but IVF and other fertility treatments. So that's something I monitor closely for my clients. And I would deem that as a healthcare issue, even though the executive order itself was not necessarily like having to do with Medicare or Medicaid or the FDA. And then also another area that I closely monitor is AI in healthcare. And President Biden put out an executive order on AI. And it was the first time that healthcare was explicitly outlined in terms of what the White House wanted to regulate and how the agencies were going to work together to regulate in that space. And President Trump did rescind President Biden's artificial intelligence executive order. So it'll be interesting to see what he does if he replaces that. President Trump was the first president to have an AI executive order. He's obviously very close to the industry. We're looking to see what he does in that space, but I would categorize that as a major implication for the healthcare industry as well.
Lots and lots of ways for changes to occur as we watch this transition of power continue. And so I want to thank you all first and foremost for providing some clarity during a very unclear time. I, for one, have learned a ton, and I'd like to wrap up by doing a round robin with the same question, which is how can industry advocate for itself? If one of these changes is unfavorable for any reason, what is one way, that a healthcare or a life sciences company can voice their opinion in this instance? And so, James, if you wouldn't mind, I'd like to start with you. What would be your recommendation for a life sciences company to advocate for itself amidst all of this change?
Yeah, I mean, I think there will be a lot of opportunities. I would say you should take a holistic view to thinking about how to address it. When a new regulation comes out or a new guidance comes out, there'll be opportunities for comments and going to the agency and going through that process. But I'd also say, think about the judicial route, think about the congressional route, think about other groups within agencies. I mean, I think taking a more holistic view because, this is likely to be different than what's happened in the past. And I think you need to probably be open to thinking more creatively. And this isn't just, well, this is the process FDA does. Maybe FDA isn't the audience you want, or maybe it's a different group in FDA that you want to be talking to. So I would keep that in mind and just sort of in thinking about how to advocate, and also just staying on top of what's happening, not necessarily acting based on every news report or every statement that comes out, because those change need to be interpreted and all of that. but just, be aware of what's going on and sort of think strategically about the many avenues you might have open to you to advocate.
Definitely. I liked what you said before, I liked what you sort of referred to before as the tension between HHS, FDA, other agencies, and it sounds like that could be a real advocacy tool here. As well, utilizing all of the different agencies to your advantage as industry might see fit. And so, Rob, passing the mic to you, same question. What would be your advice for advocating for yourself, your business, during the second Trump administration?
I'd like to pick up on the impact of the Loper decision and how it affects healthcare manufacturers, healthcare providers, healthcare investors, the entire healthcare industry. Uh, because of Loper and because agencies can no longer rely simply on deference to their interpretations of the law, that means agencies will have to work harder to justify their actions because, again, they can no longer rely on just a simple deference argument. So, for regulated parties, that means that they have more opportunities to advocate for themselves, more opportunities to insist that agencies explain what they're doing and that they participate in that action. And if the action is unfavorable or arbitrary, then it's much easier for a regulated party to come to court and to challenge an issue, particularly on issues of law, because the takeaway from the Loper decision is that courts will decide issues of law. They will take into account factual findings by an agency, but at the end of the day, courts and courts alone will be deciding issues of law. So where agencies uh, are stepping over the line, wherever that line happens to be, uh, there are more opportunities to check arbitrary action. So certainly watch what agencies are doing, and certainly get involved much earlier in the process.
Got it. And Rachel, for you, last question, given sort of all of your experience across the branches of government, how would you recommend that these businesses advocate for themselves? How would you recommend that they stay informed on what to advocate on? And what would sort of be your advice there for just keeping up with the deluge of information as we transition to the second Trump administration?
Yeah, I think we're seeing the pace that the Trump administration is going to go at, right? President Trump and his advisors learned a lot in their first administration. They now know how DC works or how to work with Congress or not work with Congress, and they've learned a lot. So they're going to move very quickly. And I think it's going to be very important to keep up with this rapid regulatory and statutory changes, not just at the federal level, but as the state level too, as states respond to what's going on at the federal level. I will tell you that I have several clients that have that I just do monitoring for, and it's not just sending them news articles, but it's really looking at places where they need to be on defense and also opportunities to get them on offense. And as Rob said, to get in there early, and as James said, to have a holistic approach. So I would definitely recommend that. And then I'll just put a plug in. You said I sit in both the DC and Baltimore offices, which is correct. But today I'm in our Baltimore office, which is down the street from CMS. And part of the reason that we're here is because we host people that want to meet with CMS. I sit next to two women who formerly worked at CMS, and we have a lot of knowledge and proximity in that space. So there will be opportunities on the issues that our listeners and our clients feel strongly about to come to CMS and meet with the people who are making those decisions before they make them is generally the time you want to be talking to them. So those are my two recommendations as we start this new reality in the Trump administration.
Definitely. I am going to borrow from the vote early, vote often that we all heard in November and change it to advocate early and advocate often. And it sounds like there are quite a number of ways to be able to do that. So thank you, Rachel. Thank you, Rob. Thank you, James, for taking the time to participate in today's discussion about the Department of Health and Human Services, CMS, FDA under the second Trump administration. And thank you to all of our listeners. I'm your host, Marjorie Scher. If you like what you heard today, please don't forget to subscribe. We'll be putting out a lot of content about healthcare under the Trump administration. Diagnosing Health Care is, as always, available wherever you get your podcasts.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.